there's some stairs here. I'm the one obstructing them. Can I please have Alim's profile? Thank you. He's a barrister. Okay, thank you. Alim is a barrister and solicitor qualified in Canada and was admitted as an advocate of the High Court of Kenya in 2009. I'll skip some parts because the panel, the profile is still being projected. He undertook his law degree at the University of Kent, where he graduated with an upper second-class honors, and thereafter went on to complete his master's degree at SOAS University of London, where he graduated with a distinction. He presently serves on the board of several private and public entities. He brings significant experience to the firm in the practice areas of real estate law, commercial and in litigation, arbitration and mediation. He's also an adjunct lecturer at the Strathmore University School of Law, where he teaches international commercial arbitration, and also he's a tutor at the Chartered Institute of Arbitrators panel of tutors. He's also a member of the ICC Kenya ADR and Arbitration Committee. Alim, I'll keep looking at you with a side eye so that we keep time. Later on, you'll tell people how you know Justice Visram. Thank you.
Thank you very much, Mercy, for that kind introduction. I'd like to introduce our panelists, and I'd like to also welcome the audience here today. And I'd like to welcome everyone who's logged in virtually and is following along with us. They will all have an opportunity to ask questions as well through the online platform that we were introduced to earlier. If we could please pull up the profiles of our panelists. Thank you. Honorable Justice Visram is a retired judge of the Court of Appeal, and he brings with him today experience from the bench and as well as experience as a mediator. He has also been trained as a trainer of mediators at the Center for Effective Dispute Resolution, CEDAR, in the UK, and presently is practicing as an arbitrator. In addition to that, he's also the chair of a constitutional tribunal that has been established by His Excellency the President to investigate misconduct of judges. Thank you. Our next panelist is actually our present Vice President of the International Court. As our chairman of the Chartered Institute said earlier, we're very proud of her to be both Kenyan and the Vice President, and we're very happy to welcome here today. She is also a practitioner and an author and a writer, and has held various leadership positions across many organizations, including the International Law Association, ILA Committee. She has also been the president and co-chair of the Africa Group of the IBA Arbitration Committee and director of programs of the African Association of International Law, among many others. If I was to go through them all, we would be even more proud of her. I'd like to take us to our next panelist here, the Honorable former Attorney General and Professor Geeth Muigai and Senior Counsel. We're also very lucky to have him here today. He's a chartered arbitrator and has been, as I said, the Attorney General, which means he brings significant experience in terms of international commercial arbitration and litigation in that position, as well as in his position as senior counsel of a prominent law firm. He also holds a PhD, and there's a lot that we can hear from him today in our discussion. Our final panelist, who is with us virtually, is Ms. Jerry Kariuki, who is also our Kenya representative to the ICC Court at present. Jerry is also a tutor at the Chartered Institute of Arbitrators and has taught many of us who are present here today. In addition, Jerry is the current chair of the Dispute Adjudication Board, which has been set up to midwife an international geothermal project and has brought that to fruition. Jerry also practices in the areas of real estate, conveyancing, probate, succession, and general commercial law. So we welcome her here today as well. Thank you. So our topic for today, or our discussion for today, is the advantages of arbitration over litigation in commercial business disputes. And as I say that, feel free to also talk about where you feel litigation is an advantage over arbitration. So it's not a one-way conversation, but rather a discussion. I'd like to start off by asking the judge a question that is based on his perspective from the bench. Having been a judge for 20 years, do you think arbitration really has any advantages over litigation?
Yeah, thank you. Thank you for this opportunity. And thank you also for the opportunity to reconnect with my old and very eminent colleagues, my dear professor here, with whom we've had so much interaction, both on the bench and outside of the bench. And Jerry, we can't see you, Jerry, but Jerry has also been a colleague in many other ways, especially in the mediation field when I was chairman of the Rules Committee, the Judiciary Rules Committee. And Jerry has been very active in that part of her professional life. So thank you all. And coming to the question, whether arbitration is better than litigation, and especially as to what I believe, having served on the bench for 20 years and having seen many, many different kinds of cases, I want to focus on one particular area. And that essentially is, as you all know, if you come before a court of law in litigation, you simply cannot pick your judge. You cannot go to the Chief Justice or to the Registrar or to the President of the Court of Appeal and say, I want to be heard by so-and-so. It'll never happen. In fact, the judge will be immediately disqualified from hearing a case if there was a preference shown for him. And this part is particularly important because in arbitration, you can actually pick your judge. You can pick your arbitrator. And the big advantage of that is that in fairly complex and specialized kinds of cases, you want your arbitrator to be an expert in that particular field. For example, in the construction industry, there are very many complicated litigations, issues arise in our courts on construction, other specialized areas of environment law, many, many other cases that are fairly complex and require the services of an expert. And you might not find an expert on the bench that you're appearing before. There may be experts in the judiciary on that particular subject, but not necessarily assigned to your case. And I have one example of working with a very eminent senior judge who had spent all his life in criminal law, never taken a case outside of criminal law, and was appointed a judge. And his first assignment was in the commercial court, Milimani, doing a commercial case. And you can imagine what would happen to the litigants, not just to him. But many judges will rise to the occasion, as did this judge. Eventually, he became so good at almost everything, but it took time. And so it's a big risk to go before a judge in litigation over a very specialized or complex issue that the judge has to deal with. And so I think arbitration is certainly better.
So qualifications and expertise, I think, are very important aspects of arbitration, and that's a great perspective. I'd like to move to the perspective of someone who's been a party to some of the biggest arbitrations in the country and has been a party to international commercial arbitrations. Professor, as the AG, you may have sat through international arbitrations and of course a multitude of litigations. The Attorney General is a party to both. Can you tell us a little bit about one of your experiences and how arbitration was significantly different from litigation and whether you felt that was an advantage or a disadvantage?
Yeah, thank you very much. I would like to take off from where the judge stopped. In the 7 years I served in Sharia House, we were involved in numerous international and local arbitrations. And one of my take home from that experience was how very useful it is to appear before persons who deal with that type of dispute on a regular basis, so that the learning curve is not as steep. And I found that in some areas of international commercial arbitration, the arbitration bar is quite small, and you end up with the same people in different matters at any given time. They know each other, they respect each other, they are open with each other, and there is very little room for misbehavior because you want to be appointed by the other party. And next time, and when I acted against you this time, next time I will recommend you to act with me and to be with the same panel. And I found that it brings some kind of discipline and commitment. I also found that precisely because you are dealing with experts, you expedite the resolution of the dispute so that it costs less overall, because everybody knows what they are talking about. And when I talk to our colleagues in this profession, one of the things I worry about is costs. We have made arbitration expensive. I think we have transferred our perception of how to charge both as counsel and as the tribunal from the courts. And that is keeping people from us, because many people take the view that, look, Milimani Commercial Court is free. I can go and take my chances there. But the arbitrator is costing me. So the arbitrator needs to be to have reasonable costs, and so do the advocates who appear before him. The other issue with our contemporary arbitration is actually time. People go to arbitration because they want an expeditious disposal of arbitration disputes. Unfortunately, our culture here has not changed fast enough to address this issue. And we've been having this conversation with all our chairmen of the various bodies about time and the need to. And I know right now we've come around to requiring persons taking up arbitration to deliver within a certain time. And the third aspect of arbitration that I think we need to sensitize ourselves about here locally is the judicialization of the arbitral process. And in my experience, we have allowed ourselves to make the arbitral tribunal a replica of the court, with everything in between, from my Lord Chairman to this lengthy oral hearings and all manner of applications on the back of applications and so on. The flexibility that makes arbitration attractive can be lost in those circumstances.
Thank you, Professor. Professor has touched on something which I'd like to bring your way, Vice President. And I'd like to ask you, in light of what the professor is saying, are the real advantages of arbitration being maintained over time? Are they eroding? Do we see arbitration sort of slipping away in terms of what we conventionally understood to be attractive about it? What are your thoughts on that?
Thank you very much, Aleem. And I'll start by saying I'm delighted to be here today. And the first time I've been back to Kenya since COVID started. So I've been stocking up on chapatis and sukuma wiki for the last 3 days. And I'm happy to be here to talk to you about the ICC. As I had said to Aleem before the panel today, I thought I might play a bit of a devil's advocate role, and I see that the distinguished professor to my right has already started highlighting some of the issues that I wanted to highlight. So the first thing to say is that we have to resist the impulse to sell arbitration as a sort of Coca-Cola. So not to use the same kind of strategies where we encourage people to use arbitration simply as a mass consumption mechanism for dispute resolution. And the reason for that is that it's not suitable for all types of disputes. So the first threshold that we should meet, or we should be required to meet, is to ask ourselves, is the dispute that's before us appropriate for resolution by using arbitration? And the reason for that is that some of the disputes that we see, commercial disputes, should be really resolved through negotiation. And sometimes the lawyers get involved, and before you know it, you're paying tens of thousands of dollars in fees, which should never have been paid. Some of the disputes should be resolved through mediation, so getting in a third party to help you reach a resolution. Some indeed should go to litigation, and some should go to arbitration. So at the point at which the dispute is going to arbitration, you start seeing some of these advantages that have already been mentioned. You see the advantage of being able to choose your own arbitrator. It doesn't always happen for various reasons, but that's one of the attractive features of arbitration. And the second is the flexibility of the procedure, as the professor has already mentioned. So the parties are able to choose the procedure, how quickly or how slowly it moves. And you see that parties in this instance, or on this score, have different interests. Some want the process to be quick, and some want to really delay it. And with that, help of lots of lawyers who have applications to courts at every opportunity on any kind of issue, from challenging arbitrators they themselves have appointed. You see all manner of mechanisms to delay the arbitration process. So Alim asks, is arbitration living up to its promise? I think it is broadly, but if we look at the disputes, for example, those that come to the ICC court, and one of my roles is to we scrutinize awards, so we see the history of the proceedings. You see that high costs are starting to creep in and have been creeping in for the last 10 years or so. We see that the procedure is slow. So this efficiency that we're told exists in an arbitral process is eroded by the party's ability to make applications to the tribunal and to courts to slow down the process. And then we see costs going up. So, and the costs are not just the costs of the arbitral tribunal, which I think are often overstated as the highest cost. It's cost of counsel. So you see hours and hours and hours being billed for questionable amount of work. And at the point when the tribunals decide who pays costs depending on the outcome. And so we see that there's an obligation on the tribunal to check the reasonableness of the costs, but they have very little control over the determination of those costs. So what they can say is, these costs seem unreasonable, and even if my decision is that costs follow the event, I'm discounting this by 30% because these seem excessively high, considering there were only X, Y, and Z proceedings. But number of proceedings, number of applications. So for simple dispute, we should not have these number of hours being billed. But they have no control, obviously, over what counsel is billing. So even as we promote arbitration, because I think that it does have true advantages that are beneficial to the business community, let's listen to what the business community wants, and let's ourselves evaluate how we are practicing arbitration as arbitrators, but also as counsel.
Thank you. Still on costs, just before I move to Jerry Kariuki, there is a further cost element to arbitration, right? If I understand correctly, the value of the subject matter has to reach a specific threshold. Could you tell us a little bit about that? Because I think for the business community and commercial entities, it's important for them to understand just that little bit more about costs.
Okay, so two aspects to that. One is for institutional arbitrations, how costs are calculated. And you have two different systems. It's the ad valorem system, which the ICC uses, and the costs of the arbitration, that's the fees of the arbitrators, and the institutional costs, the administrative costs, are a percentage of the value of the claim and counterclaim if there's a counterclaim. So you can see right in the beginning what those costs will be. They can be quite high if the dispute is of a high value, and they can be disproportionately high, actually, if it's a dispute of low value. So there are formulas that you find in the ICC rules that will give you an indication of those costs, and those are conveyed to the parties at the start of the arbitration. So the ad valorem system is good for predictability. It doesn't necessarily reduce your cost, but it's good for predictability. And the other kind of system is the hourly rate, and that's what's used by the LCIA. And for that, you have often a cap on the fees that the arbitrators can charge per hour, but you have no control over how many hours they bill. So then it's up to the arbitrators to determine how many hours they work and what they bill. And the other element on cost and amount, I think that you're referring to is the expedited proceedings that we have at the ICC. So the ICC has introduced a system of expedited procedures, or an expedited procedure. And the reason for that was in response to the reality that not all disputes require the same amount of, the same number of exchanges of documents, for example, the same number of filings or exchanges on both sides, or indeed a hearing. So with expedited procedure, it does away with the need for a hearing, and the arbitrator decides on the basis of papers, and you have a sole arbitrator rather than a three-member panel. And the threshold for that has just increased from $2 million to $3 million. So it's a leaner procedure. It's working quite well. And we've seen it also adopted by other institutions such as SIAC in Singapore. So what that demonstrates is that institutions are starting to respond to some of the criticism that's been leveled at arbitration and trying to, within their own rules and their own procedures, introduce mechanisms that help parties resolve their disputes quickly by showing that you don't need for a 100,000 value of dispute, you don't need to have a hearing for that. But sometimes the complexity of the dispute is not proportional to the amount in dispute. So sometimes you'll have disputes that should have gone to an expedited procedure actually going to a normal procedure because you need a three-member panel for a complex dispute of low value. But generally, the complexity follows the amount of dispute.
Thank you so much. So I think what we're talking about here is various options available to parties, documents-only arbitrations, panels that could be from one arbitrator to three arbitrators. However, I think we are touching on what different institutions bring. And with that, I'd like to move to Jerry Kariuki, if you're with us and you can hear us. Because we're talking about the ICC as an institution, and we have people listening in from all over, perhaps you could explain to people and our audience listening what the difference between ad hoc versus institutional arbitrations are, and then what the ICC as an institution brings that may not be available to ad hoc arbitrations, and then maybe expand a little bit, and I know I'm asking you many questions here, but expand a little bit on the role of the ICC court, where you are presently a member representing Kenya.
Good morning, everyone. There's a bit of an echo there. I hope you can hear me properly. Now, thank you for allowing me to, first of all, for the invitation, and second, for allowing me to be present through Zoom. I'm happy to see my panelists, and congratulations. I've enjoyed listening to you. And in response to Alim, I have the following to say, sorry. Ad hoc is what we normally do, mainly in Kenya. And for the last several years that I have been practicing, mainly the tribunals on which I have sat, either sole arbitrator or in a panel of three, have been ad hoc in that they have been agreed upon in a contract by the parties. The parties may, as you well know, agree on an arbitrator, and for the most part, there's usually a default clause. For the last several years, it has been the institute, or the Chartered Institute, that has been the default nominator. Sometimes it's the LSK, then the arbitrator is appointed by that default nominator, if not the parties. So that is the mainly ad hoc. When we talk about institutional is whereby the whole arbitration process is administered by an institution. That's where the ICC comes in. And the purpose, or the whole purpose of that institutional arbitration is that the institution could be LCIA, could be ICA, could even be our own NCIA, is the one that takes charge. It is the one that sets fees, as with the ICC. It does. If we talk about administering a reference, I prefer to call them references. An administration of a reference. Normally, that's the job of the panel or of the sole arbitrator, and it's quite a lot of work. Okay, you could have an administrative secretary as well, who then assists the tribunal. But with an institution, the institution takes over everything: timing, payments, pushing the party. We have a very special role as well. We have that special role of scrutinizing the award. Danga has made reference to this, whereby after the tribunal has done all its work and rendered a draft award, it is up to the secretariat and the court itself to go through that award, keeping in mind that the court members come from all over the world. We take on that award and we scrutinize it for any errors, be they typing errors, legal errors, whatever it is, because at the international level, we would like for that award to be accepted wherever it is enforced. So one person is given the job of going through that. There's somebody called a reporter, and that reporter goes through and gives comments. So scrutiny of the awards is the process that the ICC has. It's quite a unique process, and it has reduced the number of awards being thrown out. It's a good thing. I'm thinking of telling the Chartered Institute to adopt this so as to ensure that our awards, so many awards, don't get thrown out of court. It's really unique, and it's a good thing. If only Thank you, Alim. Thank you, Alim.
Thank you, Jerry. And that really is such a vital role to play, right? The entire purpose of parties coming before a tribunal is to have their dispute resolved and have it enforced. I'd like to go a little bit back towards litigation now and come back to you, Judge. Are there any areas where you feel litigation has advantages over arbitration? And perhaps you could talk a little bit about stare decisis as you answer that.
Thank you. The biggest disadvantage I see of arbitration rests actually in what Alim just mentioned, the doctrine of stare decisis. Stare decisis is a notion that is a cornerstone of our jurisprudence. And what it means, as you all know, is that like cases must be decided alike. And what that means is that in litigation, the judgment that a court pronounces is available almost immediately to the whole world. It is a judgment that, of course, relates and applies to the parties before the judge. But the principles that are enunciated in the judgment, the ratio decidendi of that case, or the other principles that you can discern from that case are available to the whole world to apply in the next like case. And that helps in two ways. One, we're able to share the legal principles and legal notions that have been established by a judge in one case with the rest of the world, with the rest of the legal fraternity, to be able to use in another case of a similar kind. And that helps develop our jurisprudence. It helps develop young lawyers who are coming into practice and are looking to find legal principles that help them in their own cases. That is an extremely important point that I see where litigation has greater value than arbitration. Now, arbitration, as we know, it belongs to the parties. It is a private, confidential process. And not every party would agree to their decision being floated around for the rest of the world to see. Once in a while, you will see an award being published and big advantage of litigation is that there is a process of appeal. Now, where parties definitely want their case to be heard by one person or a panel of three and call it a day, whatever the reward might be, and whether it is favorable or unfavorable, whether it is fair or unfair, there are very, very few occasions when you can actually challenge the award. And it's very difficult in our courts to do that because our courts generally want to uphold arbitration awards, except for serious situations, and those are in, I think, sections 35 or so of the Arbitration Act. But there have to be very, very serious reasons to upset an award. So the appeal process available in litigation means that if a party is unhappy with the judgment in the High Court of Kenya, that party has an opportunity to move forward to the Court of Appeal, and in some cases, very limited cases, even to the Supreme Court of Kenya. So I think those are the two main advantages of litigation, I think.
Thank you. So predictability versus perhaps confidentiality, and perhaps some of the difficulties in vacating an award. I'd like to go back to you, Professor. Has this been a tension? When you were Attorney General, did you have situations that were highly confidential, perhaps, that you would have wished to pursue arbitration over litigation, but were confounded by lack of authority or precedent in that setting? Was that difficult to resolve, or how did you go about it, and what were some of the insights that maybe you can share with us from there?
In the very nature of the disputes that government is involved in at an international level, relating, say, to huge infrastructure projects or major contractual obligations, government is interested in confidentiality for obvious reasons, including the fact that the government does not wish that the international financial markets should become privy to information that may otherwise affect the financial standing of government, et cetera, et cetera. So we did find that arbitration worked for us. It was confidential. It was by specialized individuals. And one of the things that I did in Sharia House that I think moved the process a step forward is that when I went to Sharia House, I found that government farmed out disputes to quote unquote international law firms. And I stopped that. I said, no, if government wants to consult external lawyers, we will have Kenyan law firms who will source international support. And the consequence of that, in my very humble view, was that we started building a local capacity to do fairly competently some international work of our own. Since I left government, I have been involved in a number of arbitrations and some cross-border arbitrations, and I have worked with other governments, and I have no doubt that Kenya has a distinct advantage in that regard, in terms of competence, in terms of familiarity with the processes, and so on. Now, one of the problems with litigation, especially international commercial litigation, is just that, especially in the context of the UK, where most of this litigation would take place, is the structure of the legal profession. So you have to end up with, you have to instruct this firm of solicitors, and then they will instruct some junior QC perhaps, and then some real heavy hitting QC, and it's quite a long and tedious process. So I am one of those who are in favor of arbitration. And one of the things that I consider a great success here in Kenya over the last 10 years is that finally we are getting to an understanding of the process. I used to say some years ago that the worst enemies of arbitration is the legal profession. Both the advocates, because their default position is, let's go to court, let's meet in court. The advocate's remuneration order, another big enemy of progress, in my opinion, but you haven't invited me to talk about that. Now, I think the legal profession itself, meaning the advocates, have begun to appreciate that you can deal with many arbitration files in a year and close them and charge your fees and move on, while matters are waiting in court for a long time. So they've understood why this makes a lot of sense. But our biggest victory has been the judiciary, because the judiciary had a knee-jerk, I say this with tremendous respect to my great friend, the judge, the judiciary had a knee-jerk reaction to arbitration and other alternative dispute settlement. And that was, isn't that our work? Who are those other people? Isn't that our work? Shouldn't we be doing that? But I think we have succeeded, and we owe it to the institutions themselves. We have convinced the judiciary we are actually partners, and we are not taking work from you. We are going to do the heavy lifting, and you will still be entitled to supervise whether we've done the right thing in the right way. And this partnership, I think, is bearing fruit. Most judges in the commercial division, they don't entertain a matter twice. They say, do you counsel, you have an arbitration agreement? Yes. Then we have to comply with it. I'm sending you straight to the institute to get this matter processed in that way. Secondly, the judiciary has understood that it is not business as usual when you are dealing with arbitration claims. Because if you have an application, say for the preservation of the subject matter of the arbitration, the judiciary has understood that you can't keep the ruling on that small point for 9 months or 1 year or 2 years. It has to be expedited. Because that's what the parties want. And finally, the enforcement. I think that I've been involved in a number of fairly substantial enforcement of foreign arbitral awards. And the jurisprudence is settling very nicely. And the judges, I think, are on top of the issue. There is that bogeyman called public interest. Yeah. And I think my teacher used to say that the public interest is a runaway horse. Nobody knows what it really is. And I think the judiciary is beginning to understand that Kenyan lawyers, given a chance, they believe there is only one law in Kenya, the Constitution 2010. So they say, Your Lordship, the Constitution 2010 does not permit, it requires a fair hearing. Then another criteria other than the criteria set in the UNICITRO model and set in the Arbitration Act of Kenya had begun finding its way into the jurisprudence. But I think now the judges are saying, no. Let's stay with the law, the narrower law. Some of you know that I personally am deeply suspicious of something called the spirit of the law. I never want to look for the spirit of the law when the black letter of the law is staring at me. I like to go with a black letter and so on. Finally, I think the jurisprudence has settled on the question of appeals, because it was a gray area and it caused some confusion. The Supreme Court has weighed in, and I think now we will follow that. So I'm happy myself. I think that progress is coming, but it is still a work in formation, and we keep working at it.
Wonderful. Professor, if you don't mind, I want to take you back to enforcement for a second. And we won't talk about the spirit of the law, but we'll talk about the spirit of arbitration. Of course, one of the reasons that parties get into arbitration is that they may wish to enforce their award in foreign jurisdictions. Have we had trouble with that as Kenya, as a country? Have we had trouble enforcing awards in foreign jurisdictions? Do you think there's been difficulty or there has been ease in enforcement of foreign awards? Where do you see that going?
Well, I think that most countries here on our continent have signed on the New York Convention, so that in principle, the legislative framework is in place. In practice, it's not always been easy to enforce in jurisdictions that the judicial culture has not yet accepted that an award coming from outside requires minimum scrutiny. In fact, I think the judicial culture in our region, in the continent, is that an award coming from outside requires maximum scrutiny. And that has its own, it has had its own challenge. But I do think that here in Kenya, our own courts are enforcing foreign awards with at a fairly good rate. And when I was in government, whenever I talked with my colleagues in the judiciary, I would bring up this issue that how we enforce foreign awards, for example, or foreign judgments, is part of how we are viewed as a destination to do business. the more we hold judgments or awards in abeyance, the more suspicious businessmen are across the world to
Vice President. And I think Professor touched on it, and he said that some jurisdictions have their own resistance to arbitration and may treat it with suspicion depending on where we look at. Recently, there's been the emergence of commercial courts in jurisdictions such as Singapore and many others that are targeting commercial entities and trying to serve them as best as they can. And these are specialized courts that seek to speed up the process. How does that bode for arbitration? Do you think that decreases the attractiveness of it, or really even its use moving forward?
Thank you very much. I'll answer, too close to this. I'll answer the question starting off actually with something that the judge said about binding precedent. In 2016, there was a speech by Lord Thomas, who is former Lord Chief Justice of England and Wales. And his criticism of arbitration was that it was stunting the development of the common law. So that a lot of commercial disputes were going to arbitration, and the law was being developed in secret. And therefore, it was not possible to know where the common law had got to in that sphere. So he had a radical solution, which was not met with any enthusiasm in the arbitration community, which was to expand the scope of Section 69 of the English Arbitration Act, which allows for a limited scope of appeals on law. Now, picking up also on what Professor Muigai said about developing the judiciary. So if you think about the binding precedent and you think about also the developing the judiciary such that it supports arbitration, because no matter how much arbitration you have, you need supervisory courts. And you need those supervisory courts to know the limit of their mandate. Otherwise, they start encroaching in on the role of the arbitrators. So in response to all of this, and in response to some of the criticisms we discussed earlier on lengthy procedures, runaway costs, we've seen that some jurisdictions are investing quite heavily in developing commercial courts that have the excellence of the famed English Commercial Court. Now, it's interesting to recall that when the English Commercial Court was set up in 1895, the purpose for the business community was to have a cost-effective and efficient mechanism of resolving disputes. So what that shows us is that litigation as a mechanism of resolving disputes is not, it's in itself against efficiency and against cost effectiveness. So what these jurisdictions are doing, and we're seeing this in Europe, in the Netherlands, in Germany, in France, in Singapore as well, is to really develop the commercial courts so that those participating in cross-border international transactions can resolve their disputes in those courts efficiently and cost-effectively, but that the decisions that are taken by the courts contribute to the development of the commercial law in those jurisdictions. So, of course, there's some limits to how much that can develop. We see those limits particularly in Germany, where even though there's an offer of having proceedings in English, the constitution of, or that is the legislation that governs the constitution of the courts requires that proceedings are in German and that judgments are in German. So there's already a barrier there. It's the same in France, where they've set up chambers at two levels, where proceedings are in English, can be in English, but there's still a requirement that judgments are in French. But what this shows us broadly is that the courts are fighting back. So even as we talk about arbitration amongst ourselves and how we can make it work better, the courts are not sleeping. They're thinking about how they can take back some of that high-ticket commercial work by making the proceedings in those courts truly efficient. So that's the fighting back point. But the secondary point, which I think is one that, regardless of what you think about the potential success of those courts, and frankly, at the moment, there's not that much success. I think Singapore might do well, but the others are likely to struggle to really attract a lot of the high-ticket arbitration work, is this supervisory role that Professor Muigai was talking about. I think you invest in arbitration only at the peril of arbitration. And unless you're truly investing in the courts, ensuring that the judges are on site, ensuring that they have the resources to understand how they need to apply domestically these international instruments, such as the New York Convention, the anti-Trump model law, and others, then the joys of arbitration are lost. Maybe I should stop there.
Interesting, thank you. So there is a turf war playing out over jurisdiction here. We don't have much time left, so I'm going to address the last question to Jerry and then take questions from the audience. Jerry, what we've heard come up a number of times is supervisory. The word supervisory has popped up a few times, and I'd like you to elaborate on it, because when we talk about advantages of arbitration over litigation, I think it's easy for people to think that litigation is entirely, or rather the court is entirely divorced from the arbitration proceedings, which is not always the case. In fact, there is a role that the court may still play, and perhaps you can explain to our audience how sometimes litigation and arbitration work hand in hand, or perhaps the court has a role to play during arbitral proceedings.
That's a good question. If we look at our own act, we'll see section 10 of our act. Look at it. And what it says is that the courts can only interfere within an arbitration process as permitted by the act. So what courts do is provide support to any arbitral tribunal to allow, or let's call it a facilitator, I think that's a better name, to facilitate the process of arbitration. So if, for example, you have a witness who doesn't want to come to the tribunal to give evidence, you party apply to the arbitral tribunal, and make a request for leave to approach the High Court. The High Court then takes that application and grants the summons, let's call them the witness summons. So that is acting as a facilitator. I'll not call them a supervisory role. They are facilitating the process of arbitration. So it is as a support for that process of arbitration to ensure that it flows as smoothly as possible. Just to go back also to the training that we have. Remember that there is the substantive law and also there is the procedural. That's where the Arbitration Act comes in. Okay, so for the place of arbitration, Nairobi, it automatically means that the Arbitration Act 1995, as amended in 2010, applies, right? If, on the other hand, you have the place of arbitration as England, then that means the Arbitration Act 1996 applies and you have to seek assistance from the English courts. That's the whole business of arbitration. So that's why it's so important for our courts to work well and to support arbitration. As you heard from Danga, the courts are fighting back in places like England. Ours, on the other hand, are providing the support that we need. Okay, they have made that complete turnaround, as Professor Gidu said. They are supporting the business of arbitration. And in fact, our government has also made some strides in supporting business, making the ease of doing business even easier. So with our courts working well, we then will be an attractive place for arbitrations to be held. Good enough?
Thank you very much, Sherry. I'd like to invite any questions from our online app. I don't know if Mercy is able to help beam the questions so that we can invite our audience to also play a part. So I think the question is, do you see the business community here embracing arbitration more? And I'd like to open that up to anyone on the panel who would like to potentially address that question. maybe we can start with you, Judge.
Yes, that's the answer. And the reason really is that because of a huge backlog of cases in our courts, business people simply have no choice but to go to private arbitrations. That is one single important reason. Because of the nature of the dispute and because of the business reasons, they want to get back on track very quickly. They want a quick decision. And so the business community certainly prefers arbitration more. Now, I got a sense from hearing other panelists that there may be some competition between the courts and the arbitration process, that courts want more work, arbitration, and don't want arbitration to take away work from the courts. Coming from where I am, I see actually the very opposite. There is no competition in my mind. There never has been. We are very happy for many cases, and I say we're thinking I'm still in the court, but the courts are very happy. Other processes take over because the backlog is enormous. And an average litigation in a court of law in High Court can stay in the High Court for up to between 5 and 8 years, and Court of Appeal 5 years. So that is the kind of time frame we're looking at an average case. And that is why we, even in the courts, recommend arbitration whenever that's possible.
Thank you. Vice President, your perspective?
I would say yes. And my reason for saying yes is that we're seeing an increase in cross-border transactions. And that's usually, arbitration usually closely tracks the increase in cross-border transactions. We're also waiting to realize the promise of the African Continental Free Trade Agreement. So there's an increase in inter-Africa transactions. Now we'll obviously have more disputes, and those are likely to be resolved through arbitration. But I hope not only arbitration, also mediation and other mechanisms. But that will itself fuel the increase in the use of arbitration.
Great. Professor, your perspective?
Yeah, I think I would go with the presentation we received from the chairman of the Chartered Institute about the growth in numbers. And I think the numbers speak for themselves. Our caseload is growing by leaps and bounds. And I think most senior arbitrators are reasonably busy. And I think we should thank the way the chairmen are running it's what we have done, I think, over the last few years is professionalize the distribution of work. And therefore, virtually every senior arbitrator is quite busy, and the junior ones are being tutored in that process. So my answer would be yes.
Wonderful. So the future is looking good for arbitration by the looks of it, between the backlog of cases, the cross-border disputes, the complexity, and increased capacity. I think we may have time for one more question for the panel. I'll wait till Mercy waves her hands at me wildly to stop, which I think she's about to do.
Okay, since you started late, I can give you 3 more minutes, but then during tea break, I'll just eat all the food on my own. Is there a question on the app that is outstanding?
There is one here. I can read it out to the panel. We haven't dealt with it yet. So we'll all forego the milk in our tea and
yes, no sugar.
So the question here is, the Nairobi Center for International Arbitration has provision for an arbitration court. The question for the panel is, would the establishment of this court, an NCIA court, be an answer to the bottleneck encountered in seeking assistance in arbitration?
The short answer is no. And the reason for that is because an arbitration court is a misnomer. It actually doesn't have the same kinds of powers as the domestic courts, which have the supervisory and facilitation, as Jerry said, authority and power. What an arbitration court does is to help with the procedural questions that come up within the arbitral process under the institutional rules. So the kinds of decisions that this type of court takes are to do with appointment of arbitrators, challenge of arbitrators, payments of advance on costs, withdrawal of claims, and so forth. So it does not have analogous powers to those of domestic courts. So I think it's a good idea to have an arbitration court within an institution, because that permits the institution to draw on the expertise of members of the arbitration community. So they help it in taking decisions on these procedural questions and reduce the workload of the secretariat, which is doing other administrative work, such as corresponding with the parties. And linking that back to the question that you had asked Jerry earlier about the advantages of ad hoc or institutional arbitration differences. One of the big advantages of institutional arbitration is that it has precedence of the decisions that it takes on these types of questions, on challenges. So the standard of challenging, what is the standard that we have to determine whether an arbitrator is potentially not independent or not impartial. So there is a body of decisions that exist within these institutions that help the institutions take subsequent decisions. So that's an advantage with setting it up. So I would encourage NCIA to make use of that provision and set up a court. I sit in a different office, but I do encourage that domestically.
Thank you so much, Vice President. Any other perspective from our panelists on that question, or should we move towards one last question?
I'd like to say something.
Last question, and after this we'll close, is do you think the fact that the ICC intends to publish more and more awards may lead towards binding precedent or at least harmonized solutions? If yes, is this truly what users want? Again, I open this up to the panel, whoever would like to take the question.
I doubt, speaking for myself, that you can have binding precedent in that context. What I think you could have is a more harmonized jurisprudence, and that is already happening in the sense that to the extent that similar questions are being determined by different tribunals, reference is made to how the matter was dealt with in another matter. And over time, the jurisprudence sort of settles so that it's not swinging too wildly as sometimes has been the case. So I think that it's a useful thing in that regard, and I would support it.
Would you like to weigh in on that?
I think there is no such thing as a binding precedent. Even in the High Court, one judge is not bound by the decision of another judge until that situation is resolved in the Court of Appeal. Even in the Court of Appeal, one bench is not bound by the decision of another bench. So what we might say, not binding precedent, but persuasive precedent. These decisions can be very persuasive. Other tribunals and other judges may learn a lot out of this. They're extremely valuable. They've been rendered by experts in their field. And surely, if I came across a decision of the tribunal on a specific issue, specialized issue, I would be very happy to use it, to be persuaded by it, but it can't be binding either on me or on any other arbitrator or on any other tribunal, but it can be very persuasive.
Thank you very much, Judge. Any further perspectives on this? Vice President, would you like to weigh in?
Just to say that the motivation for the ICC in publishing awards, and of course this is with the consent of the parties, is really a push towards transparency. So in response to the question or the criticism earlier on that the law is developing in secret, if you publish the awards, then you can see how the law is developing, and as the President and the judge have already said, then you can be persuaded by the way in which the law has been interpreted by a particular arbitrator. You're not bound, but it can be helpful to have that available.
Thank you, Jerry. We haven't forgotten that you're with us. I can still see you. Would you like to weigh in on the discussion before we close?
Yes, I think having the taking into account the harmonized solutions and the persuasiveness, I prefer that rather than binding. I think will take away the beauty of arbitration, of having unique solutions to each and every problem that's presented to a tribunal. You will take that away by, moving in favor of binding solutions. Each tribunal is unique, and I think it's best that we keep it that way. Otherwise, we're moving again back towards the courts, and arbitration then will not have any place. So I think let's think about harmonized, let's think about persuasive, as Judge has said, rather than looking for binding. Thank you.
Thank you so much, Jerry. In the spirit of harmony and having a harmonious program for the rest of the day, I will now thank all the panelists for their contributions. Thank you all so much.